docket. That is case number 106210, State of Kansas v. Ortega.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Christina Ortega. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, just a reminder, this is a Finney County case involving a situation where my client, Christina Ortega, had been out of state for a short period, well, for some period of time, and had left her children in the custody of her mother, and at some point had learned that SRS had come and taken the children. And when she came home, at least her testimony was that she was told she could get her daughter in particular we're talking about here, went to the school to get her daughter and was told by school administrators she could have no contact with her daughter, and as might be expected, reacted strongly to that, and ending up causing her to be asked to leave the grounds, which she did and never came back. So we're dealing here with this situation of attempted aggravated interference with parental custody by the daughter's mother in this case. Your Honor, the Court of Appeals...
And she was arrested then at the care providers?
I think she was arrested at SRS then later. The Court of Appeals found in this case several errors, and the main distinction, and I think at least one of the primary issues then before this court, is the disagreement that we see between the Court of Appeals majority and the Court of Appeals dissent, whether any of those errors require reversal. The Court of Appeals found that the district court erred by failing to give a mistake of fact and law instruction. The Court of Appeals found that the district court erred by failing to give an attempted interference with parental custody as a lesser attempted aggravated interference with parental custody, and that was error, and also found prosecutorial misconduct. The main distinction between and by the way, and so all of those errors were found by the Court of Appeals, and there was no cross-petition for review by the state in this case. So I think those things are established as errors now, and the only question is, are they reversible error with regard to those instructional matters? The dissenting judge, Judge Malone in this case, found a couple of the errors individually were reversible, specifically the failure to give the lesser and the prosecutorial misconduct. And so the question before this court is whether Judge Malone is correct that some of these errors individually were reversible, or even whether these errors in combination were reversible as cumulative error. Your Honor, I think when we look at the facts of this case, when I studied it and reviewed this thinking about the argument, I kind of tried to think, why do we have this distinction? What's the heart of this distinction between the majority and the dissent in this case in the Court of Appeals? And it has to do with the layout of the Court of Appeals majority is exactly correct, that the evidence is strong that the daughter in this case had been taken into SRS custody. There's strong evidence of that. And there's strong evidence that my client, Ms. Ortega, went to the school and tried to have her daughter go with her. There's strong evidence of that. The Court of Appeals majority sort of then says, therefore, we're done. It's almost exactly what they say in their cumulative error analysis. They admit, yeah, we didn't have a correct instruction on mistake of law. Yeah, we didn't have a correct instruction on lessers. Yeah, there was prosecutorial misconduct. Some of that prosecutorial misconduct going exactly to a mistake of law on mistake of fact and law. But she did go try to take kids that were in SRS custody. And that's sort of the rationale of the majority here in affirming. The heart of this case, though, Your Honors, has to do with what was her state of mind when she went there, and what did she know about her ability to take or have contact with her children at that point. That's at the heart of this case. And Your Honor, these instructional errors, particularly the prosecutorial misconduct that the Court of Appeals found, and the instructional error on failure to instruct on mistake, went to the heart of that contested issue. So individually and cumulatively, it's certainly our position that this court should lack confidence in this verdict. When the jury wasn't given as the Court of Appeals found, was not given proper instructions on the issues that were at the heart of this case, how can we have confidence in the outcome of this? Judge Malone didn't have confidence in the outcome of this, and we would respectfully suggest that he's right in this. Individually, these errors require reversal, and even if you disagree with that, that cumulatively, that these errors require reversal.
How do we factor in the evidence that once she was at the scene, she was repeatedly told she could not take the children, but she can, and I think by the time everybody had made the phone calls to confirm that the child's custodial situation, she was even given some of that information, yet she still insisted on taking the child. How do we, how does her state of mind, once she had been clearly informed, impact our evaluation?
Well, how clearly informed, it would still be a question of fact, Your Honor, I would say for sure. And when she's informed is also part of the question of fact, as with regard to, for example, I think the state's argument is that her going to the school by itself was one of the overt acts that supports the attempt conviction in this case. And so being told later maybe that you can't take children doesn't impact at all her state of mind when she was going to the school then.
And same would be true with signing the forms. That would have been before the information had been provided.
That's exactly right.
So the question then would be, was there another overt act?
Was there, and even more importantly, was the jury sufficiently instructed, for example, on absence of mistake, to be able to make these fine and nuanced distinctions? And it's certainly our position that they weren't. I think at the end of the day, Your Honor, I would say it doesn't make any difference in my view of the case. But even if I'm wrong about that, given the temporal sort of timeline that we're dealing with here, I think particularly it's certainly not conclusive or doesn't make it so that the evidence was overwhelming like the Court of Appeals majority suggested that it was. I don't have a lot more because I think the standard is set out, and I think particularly between the majority and the dissent here, I don't have a lot of other argument about the instructional errors and their effect.
As I read the two decisions, there was a difference in the wording that struck me, and I'm curious about this. This really goes to what we said in Trujillo about the elimination of the need to use the real possibility language. The majority in this case uses the language we adopted in Williams and then reiterated in Trujillo without that real possibility language. Judge Malone uses the real possibility language and seems to emphasize that. Could you speak to whether or not you think there is a difference between those standards? Were we right in Trujillo when we said there really wasn't a difference, or do you think the real possibility connotes something slightly different?
I think the court, this is my understanding as I've reviewed the court's jurisprudence in this area, is that the court said you were taking out that language that we've had in the clearly erroneous test for decades about real possibility, but not changing the test, that there was no substantive change when you were doing that. So, for example, I think it's correct for Judge Malone to still talk about that as he's viewing the record, the totality record here, because the court said we're not changing it substantively. That's still appropriate. As a test, you don't want to use that language. And my understanding of your case law was you didn't want to use that language because it confuses the harmless error test that you have in board. But to answer your question, is it still appropriate to evaluate evidence through that lens? I think this court said it is appropriate to still evaluate the evidence as a fact finder or as a appellate judge, making that totality of the circumstances analysis, that it is still appropriate to use that, and may help lead to the difference in here. That is there a real possibility that a correctly instructed jury on the critical issues in this case, is there a real possibility they would have come back differently? And the answer is yes.
On the other side, is the Williams test, the way we've stated it, do we have to find that they would have come back with a different verdict?
It's yes, except what does would mean? I mean, you get into these semantic issues on some level. Does that mean we have to show beyond all doubt? Does that mean we have to show beyond a reasonable doubt? Does that mean I have to show preponderance? Does that mean I have to show evidence that, like maybe we would use under ineffective assistance to counsel test under Strickland? Does that mean I have to show probable cause? Would have, and respectfully, Your Honor, I would suggest that it's one of the weaknesses of the test as it's expressed, I think, is that it does not really set out a sort of standard by which you would decide would. Because this court has said we haven't substantively changed the test, I think it's appropriate to look at real possibility when doing that evaluation, as Judge Malone did.
Any further questions?
If we decide you can't meet clearly erroneous on the instruction part, tell us why that misstating the law in closing would be enough.
Well, I think, one, you use a slightly different standard when you're talking about prosecutorial misconduct, because you've talked about using sort of the harmless, both the non-constitutional and constitutional harmless error test. And that's particularly appropriate here where the misstatement of law goes directly to the theory of defense, which was that she didn't understand that she didn't have the right to take her children from school. So when the misstatement of law goes directly to the heart of the defense, I think it's particularly appropriate. I think this court has said it's always appropriate when you're dealing with prosecutorial misconduct because of its potential impact on a fair trial, that you always use both the constitutional and non-constitutional harmless error test. And so when you do that, you are pushing into the to a different standard. And when you do it cumulatively as well.
How was the theory of defense presented?
The theory
Go ahead.
The theory of defense was that
No, I know that, but did defendant testify or?
you would think I would know that I'm saying it, but I don't remember whether she testified.
I
I'll
should know
look
that
and,
too,
and
but,
respond to that. But certainly the theory was that she had been told by her mother that SRS has come taken. There's no real dispute about the fact that somebody had come and taken the children from her mother, but also her mother testified, I do remember, that she told Christina that you can go get your children. And that's the theory of the defense, that she was legally able to go do that. And the prosecutor specifically said it's irrelevant, for example, that she doesn't know whether there was a court order.
Well, yeah, irrelevant whether she got notice of the child needed care proceedings.
And that's legally incorrect.
Yeah.
It's relevant. It may not be dispositive, for example, but it's certainly relevant. And it's relevant what? To the defense of mistake of fact and law.
Any further questions? Any more presentation?
I just wanted I would talk just a little bit about my sufficiency issue because this was attempted, aggravated interference with parental custody, and it was aggravated because the allegation was that she had taken overt steps towards taking the child out of state. That's what makes us aggravated. Just taking somebody out of school would be regular interference with parental custody. And so the question is, when you talk about the overt act, this court has said, what do you have to show for attempt? Well, you have to show overt act towards what? And it's overt act towards the charged crime. Not just a crime, but towards the charged crime. And so I just wanted to just touch on that to make the distinction that that's why we're arguing there's insufficient evidence here of actually the aggravated form of this, because her even just making some statements about it, that might show sort of intent. I think I understand the Court of Appeals reasoning that shows maybe it's evidence of, it's not very conclusive evidence of, but it's evidence of intent to take the daughter out of state. But is it evidence of an overt act of her taking the daughter out of state? And that's where we make the distinction there, that we do not believe there was evidence of an overt act of the aggravating fact in this case.
I need help getting to your point, because it seems to me that her committing the overt acts of going to the school and signing, doing everything she did to attempt to get her daughter out of school with the intent, expressions of some intent to leave the state, that those things combine to be an overt act to remove her child from the state. And your point about not having money or packing the bags or any of those things, why can those all not be subsequent parts of the plan but these be the first steps, overt steps towards completion of the crime.
It's because it seems to me that there should be, you're tying in. It seems to me if you adopt that position, that you're conflating the specific intent element of attempt and the overt act element of intent. That by showing the specific intent, you're showing the overt act. And that if, as this court has said in its cases, an element of attempt is an overt act toward the commission of the charged crime, then it seems more appropriate that although there may be intent, you still have to show an overt act towards the thing that makes it aggravated, towards actually taking her out of this state into another state. That's the argument.
we
under
would-
this
you
petition.
would have to be-
Statement of intention. Something beyond a statement of intention.
Yes. That otherwise it's one and the same. That the intent, if the intent shows is enough to make the overt act, that they're one and the same.
But one act could qualify for both.
It could if that one act was both an overt act towards the one and also the aggravating fact. If I was leaving Garden City on a plane that was going to Denver.
Yeah.
I-
If she had
I-
a plane ticket in her pocket or a car idling at the border or something.
Or obviously there's a lot of different facts, but in this case, is there any showing on the state of that first step towards moving from Kansas to Colorado? And that's our argument there.
So for example, signing the sheet at the school to get your kid out isn't enough under your calculus because that wouldn't be the aggravated form.
That's not evidence of an overt act toward taking
Leaving
the
the-
person from Kansas to Colorado.
Leaving the state, an
Yes.
overt act of leaving the
That
state.
in a light most favorable to the state, if you believe everything else, that might be interference with parental custody. Just signing somebody out, when somebody else has custody, that might be that crime. That's in fact the argument with regard to the lesser. The question that we've presented is that an overt act then towards the aggravated? Do you have to show an overt act toward the charged crime? That's what your case law says.
Anything further? All right, thank
Thank
you,
you, Your
Counselor.
Honor.
Good morning. My name is Tamara Hicks. I am an Assistant Finney County Attorney. And the first thing I want to address is that not all of the children were in SRS custody when the actual criminal activity took place. Only VO was in SRS custody at the time she went to the school. The other son that has been talked about in the case was not in SRS custody, was staying with the family member while Miss Ortega was in Colorado. When Miss Ortega came back from Colorado, she found out from her mother that VO had been placed in SRS custody, and she went to the school, went in, signed 2 documents, trying to get her child out of the school. Her comments were to take her to Colorado, that she didn't want her child living in a foster home and would do anything to prevent that from happening. One of the school resource officers contacted St. Francis to make sure that what the office staff thought, that the child was in a foster home setting and in SRS custody at the time and the mother was not allowed to take her, was true.
Why was it not error for the court to instruct on ignorance or mistake of fact?
In this particular case, the ignorance is a specific fact as to what she knew or thought at the time when this took place. We don't believe that the mistake instruction should have been given at this time. The defense also did not ask for that instruction to be given, so it should be viewed on a clearly erroneous review.
Wasn't though part of your theory was that she went to the school and all the activities prior to her gaining knowledge was a part of the act of the aggravated interference. So
And she also, after being informed by the school resource
I understand that,
officer-
but you're utilizing evidence of her activities prior to gaining that knowledge. So again, your theory is that she went to the school, and then was informed, and she went to the school, signed the form, and then was informed.
But she was also informed by her mother, who testified at the trial, that she told her daughter, when Ms. Ortega came back to Garden City, the mother told her the child had been taken by SRS and was in SRS custody. Based on that,
Didn't she also say that defendant could go pick him up?
That's what she testified to at the trial. That's correct. The grandmother of the child in question did testify that she said that to Christina.
So even though
Ms.
she'd
Ortega.
heard SRS custody, there at least was some evidence to support that neither she nor her mother understood what that meant.
The,
The statements at the trial did seem to go that direction.
the Court of Appeals says in its opinion, they talk about Ortega took the stand in her own defense, and this is buried in the middle of the paragraph discussing what she said. And I just want you to tell me if the Court of Appeals was right in what they say. They say she was not aware that VO was in SRS custody. She had not been notified of the custody hearing, had not received any paperwork regarding VO's custodial status, and had no idea what SRS custody meant. Is that an accurate reflection of Ortega's testimony?
Not all of it. Part of it, she did say that they repeated throughout their part of the case that she had not received notice of the temporary custody in the Sink case itself, which is true. She was in Colorado and no one really knew her location. She had made arrangements with her mother to come back, but she didn't because of financial issues or something like that. During that time is when VO started having issues and the grandmother said she couldn't take care of her anymore. That was all evidence that came about. There was evidence that Ms. Ortega knew the child was in SRS custody. But as far as the statement she made was that she didn't understand what SRS custody meant. So I believe that part of what the Court of Appeals indicated was part of the case.
You don't think it's accurate that she denied that she had, the first few words, she was not aware that VO was in SRS custody?
Correct.
You don't think that's in her testimony?
I don't believe it is. When reviewing this with the clearly erroneous, as far as the jury instructions, we believe that the Court of Appeals was correct when they indicated that when they could not be firmly convinced that there would have been an alternative or an alternate result in this case, that there was evidence on behalf of the state that would not allow them to be firmly convinced that there would have been an acquittal in this case. So on the issues of the jury instructions, we believe that you should affirm the Court of Appeals on this case. As to the other issues that weren't really addressed earlier, we would just rest on the brief on those.
Why isn't the statement that her lack of notice was irrelevant? Well, why wasn't that both erroneous and precluded the jury of considering the factual impossibility of going to Colorado?
Her statement over and over to numerous, Ms. Ortega's statement to numerous school officials, and also law enforcement, was that it was her intent to take the child to Colorado.
Okay,
Okay.
let's go back.
Okay.
In closing argument, the prosecutor said the fact that she didn't get notice on the child needed care proceedings that took the custody of her children and put them in SRS custody was irrelevant. Is that true?
I believe it is true, and only VO is the one that was in SRS custody at the time of this case, and we believe it's true because that would happen whether or not she had notice of the hearing. What she found out the result of the hearing from her mother prior to going to the school, and that's why we believe that it was irrelevant as to the crimes charged in this case. Maybe not to the issues involved in the Sink case. So that's why we believe it was irrelevant as to the criminal charges.
Do you have any further presentation?
No, Your Honor. Any further questions?
I see none. Thank you, counsel. You reserve 3 minutes for rebuttal.
I just wanted to answer the question, and the question I should have been able to answer better earlier, which is my client did testify, and specifically to answer your question, Justice Luker, this is volume 6, page 256, and 255 and 256 is sort of where there is this cross-examination of Ms. Ortega and specific places where they're talking to her about her knowledge, and I think it reflects this idea that we may have high expectations of what somebody understands. Certainly, Ms. Ortega understood that somebody had come and taken her children, and that it was maybe a state agency that we call SRS. We know these things. So when when the prosecutor asked her, so when did you find out they were in SRS custody? When I got back on 8th of September? Yeah. So on the morning of the 9th, the day that we're dealing with, you knew that VO was in SRS custody, correct? I didn't know I didn't know exactly if she was in SRS custody, but my mom told me that she had gotten taken away. And this is the nature of it, and I think is exactly the point that the Court of Appeals assumes, well, you knew maybe that SRS had taken the children, therefore we're done. You know that you have no right to see her or take her or do anything, and that's not the law, but that's exactly what this jury was presented with. The last point I want to make respectfully, Justice Rosen, and just this idea that I want to point out to the Court of Appeals found it was error to not give the instruction, and there was no cross petition. The Court of Appeals found it was misconduct, and there was no cross petition. So I want to make sure we understand procedurally on this, that I don't think that's law of the case, and I shouldn't be revisiting that. The real question is, on those issues, do we have confidence in this verdict?
Could you state for me what our standard of review is?
On which issue?
The jury instruction?
On the jury instruction?
Right.
The standard of review is viewed in a light most favorable to Ms. Ortega should these instructions have been given on the law and on the lesser.
Well, I was referring to the instructions about what is now real possibility having been removed from a prior decision.
Okay, I don't think that's a standard of review. That's the question about whether or not you should reverse.
All right.
And the standard of review on that is the court has to look at the record in total. And I think the standard of review for that, it's not really a standard review. You're not reviewing the Court of Appeals or a district court on that. You're reviewing the record to determine whether or not to reverse under the test that you said. Would the outcome have been different? That's the test you use. It's not really a standard of review, though, because you're not reviewing anything. You're looking at the whole record to determine whether or not to reverse.
All right, thank you.
I think the Court of Appeals found that it was not prosecutorial misconduct for the prosecutor to say that the mother, that Ortega couldn't rely on her mother saying she could go get the kids. Do you think that was error for the prosecutor to say that?
They found it was error. They found violation of the in limine order was error. They found that the statement that her not knowing about these things was irrelevant was error. Yes, we do. I did, and I believe we did argue that in our brief that the other statements also were error. The Court of Appeals majority didn't find that.
And why was that error?
Because it goes to this, it continues to go to this idea of that her knowledge is important. Her knowledge of the consequences, the facts and consequences of the custodial status, it's not just important, it's the whole case. And so when the prosecutor is making misstatements about those consequences or directing the jury away from those consequences, we believe it's misconduct.
Any more questions? No further presentation?
Thank you, Your Honor.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.